has started, but now I'm turning on
Record.
the recording. Yes,
So
it is.
in
Everything is
official
prepared.
Okay, so in official way, I'm cordially greeting all performers. It is the last seminar for today. I'm greeting also the participants to this seminar, those who are with us right now, and those who will be watching the video, because this seminar is being recorded, as Agata mentioned. So during the last seminar, I would like to cherish this day in a special way. On the one hand, it is the last meeting, official meeting of the team mediation. I hope that we can go further with our research next year. Maybe we could gather in the project around Polish-Hungarian research platform, or if not, maybe other ways of collaboration, because we are starting networking together. And I have also very important news to share with us on this occasion. By inaugurating the meeting, I would like to congratulate Magdalena, because yesterday Magdalena has defended her habilitation thesis with honor. So I'm very pleased to congratulate you, I think on behalf of our team, Mediation. Magdalena joined achieved very important step in her career, joined a professorial group, because in Poland it's very important step, habilitation degree. So it is now open space of research. It's for you, Magdalena, and Magdalena is going to start our seminar, also following the agenda for today. So Magdalena's subject for today's mediation in criminal cases, overview of research results. So Magdalena, I'm turning things over you. Please, the floor is yours.
Thank you very much. It's very nice that you remember about the yesterday occasion event. I'm very happy now, very glad. Yesterday it was too much emotions even to think about it, but today I'm ready for the seminar. Just let me turn on the presentation. Just a moment. Can you see it now? Great. Okay.
We can see.
Okay, so dear colleagues, after nearly 6 months of our collective research and already after the project's closing conference, I would like to present the results of my research part in a short summary and try to outline further research problems that may still remain to be worked out in the future, maybe again together. I will be very pleased if it will be possible. As I have repeated several times during our previous seminars, the practice concerning mediation in Polish criminal proceedings does not look very good. You know about it. You know that the statistics I mentioned many times show that only a small number of criminal cases go to mediation. It's obvious for us today. Specifically, it's less than 1%. I also repeated it twice or maybe even more times. However, what is quite optimistic, the statistics showed a rather high efficiency of the mediation proceedings already initiated, because about 60-70% of them end in a settlement. We all know it. I talk about it many times. And you know that I have formulated a hypothesis that mediation can be a very valuable tool of restorative justice. However, there are some serious problems or limitations in its application in the Polish criminal procedure. The limitations seems to be related to the lack of interest in mediation on the part of the organs conducting criminal proceedings, prosecutors and courts, suspects and defendants, as well as victims. And such a supposition that I made and repeated it today is confirmed in a report that I found some weeks ago. This report was prepared in 2015 at the request of Polish Minister of Justice. And this report contains a diagnosis of the state of the use of mediation in Poland and the reasons for its low popularity. The results of research conducted by the authors of the report indicate that both judges and prosecutors are not interested at all in referring cases to mediation. The results of the same study indicate a lack of interest in mediation on the part of suspects and defendants, as well as victims of crime. Moreover, the authors of the report recommended in this respect undertaking appropriate promotional information and communication activities, and such measures are centrally, of course, they are needed, and I agree with the authors of the report. But going beyond the framework of mentioned report and searching for further answers to the question of the reasons for the insignificant use of mediation in Polish criminal procedure, I think that attention should be drawn to victim. It seems that he or she, I mean the victim, should be the key figure in mediation. In this context, as part of my research, I pointed out that in order to overcome the lack of interest of victims in mediation, it is necessary to pay attention to the non-material benefits that the victim may obtain from mediation. I am, of course, referring to benefits of a victimological and psychological nature. I have a paper about it on our seminar, I think, in October, as I properly remember. To somehow summarize and simplify these benefits of mediation for victims, it can be said that mediation helps them to deal with victimization, the stigma of being a victim. In my research, I concluded that in order to ensure such mediation results for victims, the focus should be on who and how this mediation should be conducted. And it seems that the so-called victim-sensitive mediation formula may be the answer here. The crucial question is about the possibility of adapting victim-sensitive mediation in Polish criminal proceedings. I have already presented particular de lege ferenda postulates for the reformulation of Polish mediation regulations towards victim-sensitive mediation at the Warsaw Conference. I talk about it, so I will not repeat it today. These postulates seem achievable in a relatively short period of time. They seem to be worth considering, which does not mean, of course, that they not require further research or some kind of reformulation. However, as I have already indicated in Warsaw at our conference, they may be the first step for us in trying to go beyond the barrier of 1% of criminal cases which are referred to mediation in Poland. This, of course, will not happen immediately. In the mentioned report commissioned by Ministry of Justice in 2015, it was assumed that as a result of the measures recommended in the report, it would be maybe it would be possible to increase the number of court cases referred to mediation. I mean, in general, not only in criminal cases, to the level of 3%, but in the year 2030. So after almost 15 years from the implementation of the measures mentioned by the authors of the report, they assumed that maybe after 15 years, it would be possible to go from this 1% to 3%. However, it seems that without appropriate legislative changes, this may not happen at all. Moving on to further research problems, which may perhaps become the subject of further research in the future, I would like to point out that the victim-sensitive mediation formula is, of course, not everything. Just as the victim's interest in the mediation procedure is not everything. In order to make mediation also interesting for the suspect or the accused, or finally for the judges and prosecutors, it is probably necessary to try to answer the question of how and if it is possible to redirect the whole system of consensualism in Polish criminal proceedings. Such research is, of course, I know it's a great scientific challenge, but it seems for me essential if we want to reform mediation effectively. So I have a hope that maybe in our near future we could deal with this subject, we can somehow continue our research maybe in this direction. Thank you very much.
Okay. Okay, thank you very much, Magdalena. I hope so. And I already discussed about the possibility of empirical research, which could be interested for Polish researcher because the files are in Polish language. So it is impossible to participate directly by foreigners researchers actually, but I hope that we could then share the result of empirical research with our colleagues from the group and make a comparison, and maybe it will be possible also to conduct the research, the simultaneous research in Hungary. We must discuss about it later, and I will do it. We can continue this question and discuss around the empirical research in our group on WhatsApp. So going further with the seminar, I would like to invite the next speaker. The next speaker is Dr. Michał Peno. Michał Peno will discuss this topic and the title of presentation is also social work point of view, and this time Michael will share with us his consideration on the roadmap for legislator social mechanisms for implementing mediation. Michael, the floor is yours.
Thank you very much. I'm going to start presentation.
And chatting a while, I would like to only ask you to send me the individual reports by the 15th of December to confirm by my signature, okay?
Okay. I try to show you my presentation. It's rather short, but okay. Can you see my presentation? Yes or not?
Yes, I can see.
I can see your screen. Exactly.
And now my presentation, I hope.
Yes.
Okay, great. I'm really sorry, but I usually have a problem with this. Okay, so yes, the title is quite long. I'm going to concentrate only on one aspect of this broad and ambitious topic. I will try to present the theoretical basis for the analysis of legal culture in the context of mediation and restorative justice. There are also some normative postulates or questions, postulates addressed to legislator. I must say that I'm really happy that I managed to push forward my research. I'm happy that some of the previously analyzed elements of my conception match other new discoveries in relation to legal culture, creating a coherent picture of the reality in which the legislator operates. So I'm also really happy and must say that I have confirmed and developed some previous issues. So today I just wanted to signal it. Okay. So I will tell something about models of legal culture in the context of mediation, and then I will use some conceptions, especially conception of the levels of the system by Carlo Tuori, who is a Finnish legal philosopher. So As you know, and as I presented during our previous seminars, restorative justice practices are shaped by the legal culture, by political tradition, and especially criminal justice identity of the system where restorative justice um, um, develop. And the projected institution of restorative justice has to reflect the role of community, case, social, legal, and cultural elements. And here is um, maybe it is too ambitious to create new conception, but I have a kind of idea of restorative justice sensitive legal culture, or mediation sensitive legal culture. That is something more than what we can see on the surface level of the law. There is something what is rooted deeper in the legal culture, and what has to be changed if you want to implement restorative justice institution. Here is what I found. There is a result of the empirical research about the legal culture. Here we have the so-called communitarian republican or common law model of the legal culture, and this model is considered as a better social and legal traditional context of the restorative or for the restorative justice. So this model of the legal culture is characterized by this for special features: strong participation of community. Here we have another one. So we know that the members of communities, the members of NGOs, organizations, and so on, are actively involved in the process of mediation of restorative justice. And it's the same is with professionals who are ready to play new roles, not only being a judge, attorney, but they want to participate in these processes. Um, of course, the fact that the problem of criminality is considered as one of the very important aspects of the quality of life. So it is treated as something very relevant for communities, local communities, town communities, district communities, and so on. And there is a tradition of restorative justice, restorative community justice. And I believe this is what I have presented during previous seminars and during the conference in Warsaw, that these are the key elements and values of restorative justice, sensitive legal culture. So we have to do something to shift our legal culture to this model, these values have to be incorporated into national legislation in Poland. And here we can see how the European or the so-called civil law model of legal culture is characterized by authors of this report. Weak participation of community, I would agree with this. Bilateral processes are dominant. It means that we have defendant and we have also always only two sides which are involved in the process, mostly professional mediators, and relevance and significance of judicial framework. We just believe in courts, in judges, in formal institution. We don't believe in the power of the communities into which we belong. And there is another very important conception, the conception of the three levels of the law by Carlo Tuori, who is well-known Finnish legal scholar, legal philosopher, because now we are talking about legal culture. It is quite easy, and this is the area, the field of the activity of the legislator, the area, the field of the surface level of the law, the level of the provisions. Of course, it's quite easy to change legal provisions. It's really quite easy to change legal instruments, but it is not enough to introduce institutions like restorative justice, like mediation, and so on. So we have to concentrate. We have to go to the deeper layers of the law. There are two deeper layers or levels of the law: legal culture and deep legal culture. I must say that the conception by Carlo Tuori is one of the most holistic philosophical representation of the multi-layered nature of law. And this conception offered by Carlo Tuori distinguishes three levels, three layers: surface level legal culture and deep culture. It is totally positivistic conception, in the sense that in the sense of the legal positivism, but I think that Carlo Tuori managed to find something very important, which we have to consider if you want to change legal instruments, if you want to change legal institutions. So here we have two deeper levels: the level of legal culture, which is created by legal practice and legal scholarship. It covers especially professional legal culture. It contains values, principles, concepts, beliefs, and practices of specific legal community. It is also about culture of the organization of courts, and so on. So we have to. So this is legal culture, and there is deep legal culture, which is built by most basic qualities of the law. So this is something like the legal culture of the whole on the whole society. And here we can see the most important, the key facts about deep culture. The first is that it is usually unconscious, but it doesn't mean that it is not possible to change it. This is the most stable layer of the law. But what is the most important, these two levels of the legal culture are autonomous from legislation decisions. So we need to use something more than new legislation to change it. So there are some assumptions of this legal culture, formal assumptions that the law is formally rational. It's Kelsenian idea, of course, internally coherent, autonomous, and so on, and some material standards, for example, the idea of human rights protection. So there is a question: how to transfer these elements, values, to Polish or Hungarian, or to, in general, European legal culture. The question is whether it is possible to transfer these elements of the legal culture, the deep legal culture, to our legal tradition. So I think that it is a responsibility of the legislator to create and to support a legal culture sensitive to mediation or restorative justice. And I think that it requires something more than new legal instrument. So here you can see what I mean, but by changing the second level of the legal culture of professionals. So we have to change the approach to reconciliation, to clients of the justice system. They have to be open up to the psychological aspects and emotions of the participants of proceedings, and so on and so on. And the also very important thing is to change the third level, the deeper level of the legal culture. Of course, it is only possible by changing the way in which citizens, members of our societies, think about justice, about mediation, and so on and so on. So the problem is that, and it is a big problem for me, that usually legislators concentrate only on the surface level, and of course if we produce new legislation, it doesn't mean that we'll manage to change something in the deeper level of the legal culture. Of course, there is a question whether result of this research describe our Polish or Hungarian reality, but I think that yes, the answer is yes. That there are very very good picture of our social reality. Um, and here is a question, the big question mark, because maybe we need to do something to convergence legal systems, our legal systems, with the system of with the model of republican model of legal system in United States of America, or in general Anglo-Saxon tradition. I don't know whether it is possible, but I think that we have to do something in order to change these two levels of legal culture in order to create operating institutions of mediation, of restorative justice, and similar. So that is what I wanted to signal to present.
Thank you very much.
Thank
This
you.
is the
Thank
end.
you very much.
Thank you very much. I must say that I'm inspired by social works, and mostly I'm researching the ecological theories when it comes to restorative justice. So I think that it is a good background for implementing mediation, other tools in new social. I would say network, or because you must build a network first to insert some new tools. So it's very interesting and really impacting legal sciences theory. Thank you very much. And now the floor is for Ferenc Santa. Ferenc, could you open your camera, please? Could you turn on your camera?
I don't know that you can hear my voice.
Yes, I can hear your
Yes,
voice,
but I my camera is open, but I don't see myself.
neither I must I must say
So
that. But you could be today without picture if it
yeah,
is a problem, because sometimes I must say it happens with but when you look at the icons of camera, it is
yeah,
green or red
it's
on your
green, of
screen.
course. Yes, yes, but
Green.
yes, green,
Okay.
green. But I try to use my PPT. Just 1 minute.
Okay, don't worry, you could be a little bit in ghostly way with us, just with
Okay.
your voice and the presentation, and it must be enough.
Yes, you can.
Yes, we can see
Yes,
your
okay.
presentation.
It's so perfect.
And
So thank you the possibility for this latest occasion, this latest presentation. As you can see, the title of my presentation is New Opportunities and Challenges of WOM and Reparation in Hungary, Mediation in Administrative Criminal Cases. As I mentioned earlier, mediation has been available in Hungary since 2007 in criminal cases. Maybe the positive practical experiences inspired the legislator to introduce mediation into the administrative criminal law in 2014. Mediation in administrative criminal cases follows very similar procedural rules and substantial conditions as victim offender mediation in criminal cases. Um, the first slide, you can see the main legal sources of mediation in administrative criminal cases. The legislation is based only two pillars. The first is the Code of Administrative Criminal Offenses from 2012, which regulates the main substantial and procedure rules concerning mediation process. And there is a special law. It's not an act, it's a Minister of Interior decree on mediation in administrative criminal cases, which regulates the mediation process in detail. And the procedure, like in criminal cases, is also of a mixed nature, since the administrative authority, which is in Hungary, is usually the police, the competent police authority, or the court has a right to suspend the administrative criminal procedure and transfer the case to mediation if the statutory conditions are fulfilled. The courts or the police decision is followed by the mediation process, which is, of course, a non-administrative criminal procedure between the victim and the perpetrator, carried out by an independent person who is a probation officer, a mediator. Only at law cannot be a mediator in administrative criminal cases. There are objectives of the mediation process in administrative criminal cases as well. According to the code, to reach a written agreement between the victim and the perpetrator in order to giving reparation for the consequences of the administrative criminal offense and encourage the future law-abiding conduct of the perpetrator. I have to emphasize that the case may be referred to mediation once during the administrative criminal procedure. Referral to mediation is not excluded if the perpetrator has already voluntarily compensated all or part of the damage caused by the administrative offense. In the next slide, you can see the conditions of victim-offender mediation in administrative criminal cases. First of all, if the relevant administrative offenses, there is a limitation, because mediation is applicable if the administrative criminal offense is punishable with a custodial arrest. These are the most serious administrative offenses in our code, and traffic administrative criminal offenses. But I have to emphasize that in case of juvenile perpetrators, this restriction does not apply. Mediation can be used in any case. In the practice, the majority of cases, administrative offenses against property and traffic administrative offenses, of course, if the illegal act has a victim. The second condition is the confessional statement, like in criminal cases, by the perpetrator. The third, the most important element, of course, the reparation. Because successful mediation requires reparation, so the perpetrator shall provide reparation by way of the means and to the extent accepted by the victim within the framework of the process, of the mediation process, or previously, if approved in the mediation process. The fourth condition is the consensus. So both the defendant, so both the perpetrator and the victim shall consent to the mediation. The fifth element or fifth condition of the process is the discretionary and subjective condition of the process, like in criminal cases, because the court or the competent police authority suspend the procedure for the purpose of mediation if the administrative criminal proceedings may be omitted based on certain circumstances, the nature of the illegal act, the method of the perpetration, the personal circumstances of the suspect. And this condition is at the discretion, at the full discretion of the court or the competent police authority. I have to say that the same critics can be said, like I mentioned, this condition concerning mediation in criminal cases. And there are grounds for refusing, or there is ground for refusing mediation, because mediation is excluded if the new administrative criminal offense is committed within 1 year after a successful mediation process. And the legal consequences of the successful mediation, the administrative criminal procedure is to be terminated. And the next slide, you can see the conduct of the mediation process, the steps of the mediation process. First, if the conditions for mediation are met, the court or the police must inform the perpetrator and the victim about the possibility of the process. The perpetrator and the victim have 8 days to file a motion to start the process. The second step, based on the decision of the competent police or court, the case is suspended for 30 days. The third, the mediator sets a date for the mediation meetings and informs the parties about it. The fourth, holding a mediation meeting. The perpetrator has only 30 days to make reparation. I have to say it's a rather short period. And the second, informing the competent authority of the success of the mediation by the mediator. And there are 2 possible cases. The mediation was successful, and the administrative criminal procedure is terminated in this case. And the second, the process is unsuccessful. In this situation, the case will continue according to the rules of ordinary procedure, the traditional procedure. And finally, I have numbers, of course. You can see the statistical data concerning mediation in administrative criminal cases. I concentrated only adult perpetrators, and you can see, for example, 2015 and 16, the numbers, I have to say, very good. But if you can see 2012 and 2021, we can see that number of mediation cases significantly decreased from 2012. And further or future research could be answer the questions that what are the reason of this negative tendency, and answer this question may be useful. The interviews, we mentioned the interviews in this group so many times, interviews with the competent police officers or judges. And thank you for your attention.
Thank you very much, Ferenc. If I may say, I think that this period, 2020 and 2021, it is a COVID period. Maybe this year also it will be decreased, and then you could see that the number will recover. So it will be twice more cases. I think that this could be in relation with COVID time, with whole restrictions, which have also in Poland impact on the petty offenses. So because in Poland we have the petty offenses cases, I'm not sure, but if you could share this knowledge with us in your article about the numbers and the consideration, it maybe will be also insightful if you could insert the basic procedure about administrative criminal offenses, the basic rules for prosecutions, like the basic whether there's a guilty principle, or because it depends also on the kind of the general rules for prosecution. Thank you very much. And of course, the next excellent speaker is Professor Adam Likser. I know that you waited long for your speech, and the floor is yours.
Thank you very much, Barbara. Dear colleagues, thank you so much for the past few months, for your excellent presentations and for your hospitality in Warsaw. And I would like to congratulate to Magdalena as well, receiving that title of Doctor Habilitatis. Now I would like to briefly summarize the possible directions of my further researches. If I ask myself whether that research on the mediation within administrative court proceedings should be prolonged, to be honest, I'm doubtful which answer would be the best answer of my question. On the one hand, there are some further questions to ask related to my topic. For example, what are the reasons for the use of court mediation by the parties within administrative court proceedings? Why does the defendant, according to his or her experience, undertake to participation within that process? Or, and this one is the most interesting one, what are those case types within administrative court proceedings in which court mediation is most frequently used? Should we even broaden the scope of case types? Answers given on such questions can broaden and deepen our knowledge about court mediation in administrative cases. But on the other hand, I have my doubts about the further research findings. Can we reach really new findings by involving more respondents, for example, 20 interviewees instead of 10? I don't think so. I don't think that the new findings will radically differ from the previous ones, even if some questions are partly new. So, if I insist that the topic of my further research should remain mediation, but without taking further interviews, what would be a good scientific target or field of research? Maybe the reasons behind the low numbers of cases solved by using mediation in Hungary would be a proper issue. Magdalena was also mentioning this problem today. I had already introduced some reasons behind that related to the administrative cases, but it would be interesting to go further, reaching some general answers on the level of the whole legal system, of the whole Hungarian legal system. Why does Italy, for example, had 11 times more cases solved by mediation in 2021 than Hungary? I heard that number only a few days ago. After that, my next question is, what if that mediation topic won't be prolonged? If we decide not to continue it, or the Instytut Wymiaru Sprawiedliwości doesn't want to have it. Fortunately, I do have some other ongoing researches, and I'm ready to propose the topics of those researches for a joint research as well. I'm sharing with you 4 possible topics. The first one is the legal and theological concepts of Christian liberty, and I do have already one longer essay on it. You can reach it on the internet. The second topic is the need for neologism of legal and administrative terminology in Hungary. It's a real and huge problem for small languages, as Hungarian language, that we do not have our own equivalents for new phenomena, and we incorporate the original English words or expressions by changing the original phonetics, and not by creating a new word. After a while, it becomes a huge problem for the Hungarian legal terminology as well, and maybe it would be the same in Polish legal language. My third ongoing topic is the situation of the Roma minority in Hungary, because, as you know, almost 10% of the Hungarian population is Roma or Gypsy, with another word, and it's one of the biggest problems, even from the criminal law, from the aspect of the criminal law in Hungary. And the last possible topic or issue for the next research could be or should be the clarity of norms. I'm not going to speak about that in a detailed way. And all these topics could be researched also within that Polish-Hungarian research platform, because as Marcin Wielec mentioned, if I understood him correctly, the next topic or framework will be somehow connected with the ethical questions of the law, and all these topics are connected with ethics to some extent. So these were my proposals. But whatever happens, I'm really thankful that we were in the same research group. Thank you very much.
Thank you very much. I can take this burden on my shoulders, so I can share your topics with the institute as a leader of our team. And I personally, I would be very much interested in the third topic, because I'm very interested into semiotics. So, but also the first one, we could find a common space. So please think about us. Maybe it will be the topic for agenda for next Polish-Hungarian research, or maybe you would plan something more on your own. So you can also invite us, and we can invite you, obviously. So we are the second time in the team, so you never know. I promise, if it will be opportunity, I will, of course, if I will participate in the new agenda and new edition, of course, I will let you know. And now it was the time for Katarzyna, but Katarzyna is not with us. So my proposition is that it will be my short speech. And then at the end, we can hear the pre-recorded audio video of Katarzyna. Okay, so I can start my speech. So the floor is to me right now. I will try to be short, but I have a topic for today. So it is not only the summary of research, but I few times mentioned about my last theory, which I inquired. So I want to share with you my consideration, and I will follow my topic, which I registered, contrary to duty norms and axiological basis for mediation, with the question, must mediation be reshaped in non-adversarial models of prosecution? Because it was my first consideration about the Polish model of criminal proceedings and vision of criminal justice in general, which led me to several conclusions. So first, let me remind you that this normative description of mediation in Polish system, criminal system, allows us to characterize mediation as a complex institution. This is first, with several features. So first of all, it is rather offender-driven than victim-driven focus, direct and indirect formulas, as we discussed before. And also one could distinguish the full mediation and semi-mediation practice. Semi-mediation, it means mediation connected in some way with prosecutorial negotiation. And also we can distinguish settlement and non-settlement driven formulas, but hopefully we have the predominance of settlement driven formulas, as Magdalena underlined. More about 70% of mediation procedures are concluded with settlement. And this is settlement-driven formula is also in correspondence with this offender-driven profile of mediation. So the legal framework for mediation in this, I would say, adjudicative, so pre-trial and trial stage of criminal proceedings is rather satisfactory, I would say, and allows for wider use. But consequently, we have this marginal practical significance of mediation. It was argued by whole Polish researchers, and it is rather related to the issue, if I may diagnose it, of a systemic nature connected with this model, the given model, not adversarial model of process of prosecution, rather inquisitorial or mixed. It depends on the point of view. So at the same time, development trends for mediation, so we have this inquisitorial model of prosecution, but at the same time, development trends for mediation can be referred to as increasing importance of victim-offender mediation against a background of probation or as a probation measures, but in enforcement procedure. So my proposal was to reshape enforcement procedure and to promote wider mediation procedure, and maybe insert some different type of mediation, also this sensitive victim mediation. So, but the question still remains, which is connected with my topic for today: why do we need victim-offender mediation in general in criminal law? It is also what Michael has argued, and whether the arguments for this institution are connected with the values: restoration towards victim, community, reintegration of perpetrator, or the argument for this institution are rather based on instrumental effect link with the pure benefits for defendant. Because as I may say, I observe this different point of view when discussing Polish mediation, victim-offender mediation, and Hungarian model of victim-offender mediation. So I started my inquiries based on distinction of two types of negotiations. As you remember, prosecutorial negotiations and defendant, so prosecutor and defendant without victim, and victim-offender negotiation in the frame of mediation procedures, so victim-offender mediation. So in effect, I indicated that the prosecutorial negotiations allow for a deep impact on the dimension of criminal responsibility, has also deeper significance for the community and even society. And as a consequence, this impacts VOM in relatively high level. So it is important how we could shape previously prosecutorial negotiation. And at this point, my research has a common outcome as Magdalena's. So unfortunately, the Polish system is an opposite side. So there is meanwhile, we have this connection, and that undeniable connection between prosecutorial negotiation and victim-offender negotiation. The Polish system is not presented in this way. So the benefits for defendant in case of prosecutorial negotiations are not obvious, and the axiological dimension of victim-offender mediation must be enough in this context. But what I'm arguing, it maybe is not enough. So, and it is not enough when it comes to the numbers, but maybe the quality of victim-offender mediation performed in Poland. So the axiological grounds are strong. It maybe could be argued in the sense based on the numbers of settlements. So, as I argued before, in Polish legal system, the context of values is the most important feature of victim-offender mediation. It is actually the unique feature which could be taken for sure. So, in fact, one can be skeptical about whether such a context is sufficient. And critical reflection is also prompted by the knowledge of Hungarian model of mediation in criminal cases, in which two variants of mediation are distinguished, as Ferenc several times discussed with us. One type is similar to the Polish model of a victim-offender mediation, although Hungarian researchers have described this model as ineffective. And while the other is limited to minor crimes, misdemeanors, under which the participation of the accused in mediation leads to a specific reduction of the sanctions. So the latter is characterized by much higher efficiency. So it turns out, therefore, that even in inquisitorial, which is Hungarian model of prosecution, or mixed model of criminal proceedings, opportunistic solutions involve the benefits for defendant shall bring certain practical benefits. So undeniable. Therefore, mediation in criminal cases cannot be only based on values, but must award some benefits to its participants, including the accused. So this is one of my practical approach. And in my research, the assumption also have been taken that criminal justice must be constructed based on cohabitation of retributive justice and restorative justice ideas. So it must be a combination. It is a mixed approach. And as you remember, the initial issue for my deliberations was therefore to approach the model of proceedings in this way. And from this point of view, victim-offender mediation is an instrument closely linked to the idea of restorative justice. But depending on its shape of the proceedings for mediation, it could be a pure manifestation of restorative justice or a compromise, a solution between retributivism and restorative justice. It could be, for example, exemplified by the ratione materia limitation for mediation, as we have in Hungary. So in this respect, it is crucial to distinguish between two variants of mediation: victim-driven mediation and offender-driven mediation. While the first one, so the victim-driven mediation, is the exemplification of restorative justice. The second formula refers to mixed approach, so restorativism and retributivism. So the analysis of mediation in relation to the restorative justice model and the retributive model can be combined with the theoretical concept of contrary to duty, which I mentioned several times, and it is the time to describe this a little bit further. So the application of this concept, according to the typization of theoretical approaches for mediation proposed in my study, as you remember, can be understood as the legitimization of restorative justice instruments. So consequently, this theory, contrary to duty, which is called also Hirschholm theory, Roderick Hirschholm theory of Hirschholm's paradox, opts for a concept of mediation in which the offender receives strictly defined benefits due to the existence of remedial procedure that is combined with mediation. So it is not exactly mediation, but a remedial procedure which is combined with mediation. So just to emphasize, conceptualizing the theoretical basis of mediation, this concept of so-called Hitchcock's paradox could be taken as a base. So when discussing this concept, following Roderick Hitchcock's statement, it was a theory announced in 1963. He addressed as one of the first philosophers the contrary to duty obligation norms. So he argued that if you have done something bad, you shouldn't make amends. So doing something bad is wrong, but if it is true that you have done something bad, it is ought to be the case that you make amends. So you must improve the situation of the breach of law. So alternatively, we must say that a contrary to duty obligation, it is a conditional obligation where the condition in the obligation is forbidden, or where the condition is fulfilled only if a primary obligation has been violated. So in the first example, perpetrator should not be guilty, but if she is guilty, she or he should confess. And by this concept, the systemic solution connected with the normative structures has been argumented. So this concept creates the ratio legis full restorative justice approach, which is more theoretical than practical, but there is also the practical assumption. So I'm arguing that contrary to duty obligations are important in our moral and legal thinking. They turn up in discussion concerning guilt, blame, confession, redemption, remorse, restoration, reparation, repentance, compensation, apology, and so on. But in this context, what was important, it was the approach of Professor Sarkowicz. I discussed this approach as innovative. So the author states that why do some systems contain norms that somehow imply a violation of other norms of the given system? So his answer was that it seems the most important aspect that the legislator has in mind when establishing such a legal norm is that it contributes significantly to the reduction or reparation of damage caused by the previous violation of some other norm of a given system. Such damages can be of various kinds: moral, psychological, physical. So it could harm individuals or even society. So a characteristic feature of contrary to duty norms is the leniency of sanctions compared to that compared to which have been applied to offender. So degree of leniency depends mainly on the seriousness or the basic norm violated and the offender's effort to avoid or reduce the damage caused. So this rather general answer to the question is connected also with the core impact of contrary to duty directive, because when analyzing the axiological dimension of mediation, which I have already said based on optimization theories, I discuss how to shape the procedure to make the procedure more effective, more axiologically granted. But the theory of legitimacy, which I'm discussing right now for mediation, goes beyond this aspect and refers to determining the impact of mediation on legal situation of the accused further, not only during mediation, but when it comes to further legal actions taken against defendant, against offender, we could say, after mediation procedure. So it is accumulated at the moment of sanctioning. So contrary to duty concept justifies the existence of premises of modification in the legal system, improving the legal situation of the accused. So in this sense, contrary to duty directives are important from the point of view of shaping the sanctioning norm in criminal law For the latter, it is to indicate an adequate penal response to the violation of a sanctioned norm, the norm which describes the prohibited behavior and so on. So this is a very important part to discuss why the penal system must be awarded by the legal norms aiming to improve the situation of offenders. So also this is a reason how to explain that even inquisitorial system must be enriched by some, as I call them, premises of modification for legal norms. So very important feature for legal interpretation. So this is from me for today. Thank you very much. And now we can open the record. Okay, it works.
Good evening, dear colleagues. The title of my today's presentation is Implementing the Principle of the Best Interest of a Child through Mediation in the Polish Proceedings for the Return of a Child. In the second part of my research within the Polish-Hungarian Research Platform, I focused on mediation as a tool to better protect children who experienced international parental abduction. First, let me start by explaining the notion of the child's best interest. It is a key principle underlying the UN Convention on the Rights of the Child, which is expressed in its Article 3, Paragraph 1, according to which, in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interest of the child shall be a primary consideration. On the European level, the principle of the best interest of the child has been laid down in Article 24 of the EU Charter of Fundamental Rights. In the Polish legal system, the need to protect children's rights is expressed in the Constitution of the Republic of Poland. It states in Article 72 that the Republic of Poland shall ensure protection of the rights of the child. The protection of the child's welfare, referred to as dobro dziecka, is a guiding principle expressed in many provisions of the Polish Family and Guardianship Code, regulating issues relating to family relationships, parental authority, and custody. For example, according to Article 95, Paragraph 3, parental authority shall be exercised in a manner that supports the child's best interest and social interest. According to the Committee of the Rights of the Child, the concept of the child's best interest is aimed at ensuring both the full and effective enjoyment of all the rights recognized in the Convention on the Rights of the Child and the holistic development of the child, understood as physical, mental, spiritual, moral, psychological, and social development, to secure the integrity of the child and promote the child's human dignity. As such, the child's best interest is a threefold concept, and it should be understood as, first of all, a substantive right of the child to have his or her best interest assessed and taken as a primary consideration when different interests are being concerned. Second, an interpretative legal principle, according to which if a legal provision is open to more than one interpretation, the interpretation which is most effectively serves the child's best interest should be chosen. And three, a procedural rule requiring that if a decision is to be made that will affect a specific child, the decision-making process must include an evaluation of the possible impact of the decision on the child or the children concerned. According to the Polish Supreme Court, the concept of the child's well-being, on the one hand, encompasses the whole sphere of the child's most important personal matters, for example, physical and spiritual development, proper education and upbringing and preparation for adult life. And on the other hand, it has a clear material dimension. It is a decision from 11th February 1997. In a more recent decision, the Supreme Court said that the welfare of the child is a fundamental value that requires priority over the interests of others, including the interests of the parents. According to the Supreme Court, the most essential element of parental authority is its protective function in relation to the child. Parents may only take into account and exercise their expectations and rights arising from parental authority in such a way and to such an extent that does not lead to a conflict with the child's welfare. It's a decision from 31 January 2018. Clearly, the principle of the best interests of the child is a key element of the international and Polish framework of children's rights protection. As we can see, it focuses on the well-being, development, and dignity of an individual child, and it emphasizes that the child is an individual subject of rights. The question arises whether, under the 1980 Hague Convention on the civil aspects of the international child abduction, the best interest of a child is sufficiently protected. I am aware that it can be a provocative question, since already in its preamble, the Convention states that it is designed to protect children internationally from the harmful effects of their wrongful removal or retention. However, the general philosophy and the overall perception of the legal status of the child in the 1980 Hague Convention raises some concerns from the point of view of the protection of a child's best interests. What seems obvious now, that a child is an individual subject of rights, is mainly the achievement of the UN Convention on the Rights of the Child, adopted in 1989, and the overall change in the perception of the legal status of the child that took place in the 1980s. It was not so evident, however, at the time of the drafting of the Hague Convention, which seeks to protect the collective interests of children by providing zero tolerance for abduction and deterring it in general. The Hague Convention leaves limited space for the consideration of the individual situation of the child concerned, which can be taken into account only to some extent within the exceptions to obligatory return. The Polish regulation in the Code of Civil Procedure implementing the return mechanism is no different in that respect. In other words, the technical approach based on the private international law deterring international parental abduction in general in order to protect children as a collective group may hinder the implementation of the principle of the best interest of a child. The international family mediation can be helpful in that respect. It provides the parents with a much less formal framework to discuss different solutions and different options, and to focus on the needs and interests of their child. This way, bringing into the return proceedings the individual children's rights approach, which is missing from the 1980 Hague Convention. The Hague Convention and international family mediation are not mutually exclusive, though. On the contrary, they can and should go hand in hand. The combination of a widely supported cooperation mechanism with the benefits of mediation allows to address the legal aspects of parental child abduction within the context of the individual family situation. In other words, the best interest of the child is best protected when international family mediation is complementing judicial return proceedings. For that, it needs to be properly introduced into the framework of the domestic return proceedings. The Polish Code of Civil Procedure creates a good framework for mediation in civil cases, but the mediation is nevertheless underused. Further awareness raising about international family mediation is needed, both for parents and family judges, for the sake of better protection of the welfare of children caught in highly escalated family conflicts. Thank you very much for your attention.
Okay, finally we achieved the end of the seminar, and I promise that today is without discussion. if we want to discuss further, we can open discussion on our WhatsApp group. So for conclusion, if I may, one could say that we achieved a lot. So because we prepared a book consists of 6 chapters, 6 innovative chapters, and we plan to publish 6 articles in renowned Polish and Hungarian journals. But of course, I hope that we have already just started our collaboration, not only in the field of mediation, but also, as Adam announced, other field which we could explore further and together. I hope that Polish-Hungarian Research Platform Third will open opportunity for us to joint research, but if not, there are other fields and other spaces to share our common work, common studies. So for now, closing today's seminar, I'm wishing you the fruitful further collaboration, and for the next 2 weeks, very Merry Christmas and lots of happiness in New Year. So I wish you all the best Christmas ever. Thank you.
Thank you very much. I will also like to wish you a very, very Merry Christmas. Have a good time with your family and make some rest, please.
And if I may, I would like just to say a few words that I'm extremely grateful for you, for the whole cooperation with you. And I have the pleasure that with today's meeting, I closed the series of seminars from our project. So the whole project was a fantastic adventure for me. And I think I can already invite you all to follow the information about next year's edition, because we are planning one. I would just like to remind you to submit the binding documents as soon as possible. So as soon as you prepare them, just send scans because you would like to close this issue before Christmas. It reminds for me also to wish you Merry Christmas. So thank you very much one more time.
Thank you. I hope that this was your favorite group to work with.
Of course, the most close to my heart.
Yes. So thank you very much.
Thank you very much.
And I see my seminars, my students from seminars who reached us here because they are waiting me. So I must log out and have a nice evening.
Best wishes for all of you. Bye.
Bye.
Goodbye.